Tune in for Series 5 of the HIP Talks, a podcast series of discussions on legal issues hosted by Hugel and Ip Solicitors, an independent boutique law firm in Hong Kong, providing bespoke legal services and exceptional client service to individuals, families, entrepreneurs and businesses, both locally and internationally. The forthcoming podcasts are the Barrister series. Over 6 episodes, the team sits down with preeminent Hong Kong barristers to discuss contentious issues related to civil litigation, employment, family, trusts and estates, as well as increasing awareness about the importance of the role of barristers in court proceedings and the relationship between solicitors and barristers when acting for clients. Hugel and Ip provides expert advice across a variety of dedicated practice areas, both contentious and non-contentious. An outstanding team of solicitors who have achieved exceptional results and recognition in the areas of dispute resolution, probate and trusts, family and matrimonial, corporate and commercial, and employment and immigration. Hugel and Ip applies modern thinking to legal services, uses technology in a contemporary office environment, and is fully committed to giving back to the community.
Hi everyone, welcome to this podcast. My name is Francis Tsang and I'm an associate from Hugel and Ip. Today we have Mr. Azan Marwah, barrister and mediator in Hong Kong from Pantheon Chambers, and we have Mr. Alfred Ip, solicitor and partner of Hugel and Ip with us today. So to start off, can I ask both of you to introduce your area of practice and what you do? Can we start with Azan?
Well, thank you very much for inviting me to this podcast. I'm a barrister and mediator. That pretty much means that my life lives around litigation and some advisory work. Most of my practice relates to family and children, estates, inheritance, but also some other areas of law, including employment, discrimination, and I'm quite well known for my public law work.
Alfred, can you tell us a little bit about what you do and your area of practice?
As a solicitor, private client lawyer, we deal with private client dispute, and family is one of them. We deal with relationship. A lot of time we advise on relationship, why it's breakdown, why it comes to a stage of dispute, what is the issue in dispute, and also we help client manage their litigation. This is how we separate our work, and we often work with Azan being one of the most reputable barrister in Hong Kong in handling the whole dispute. A lot of time, people, especially those who are embroiled in dispute, they get confused with a lot of issues. A lot of time when people are in argument, they just throw everything out. They don't understand there are issues. And there are issues that need to be resolved. There are issues that are pertinent. But there are also issues that are more pertinent, not in terms of money, but in terms of the heart. For the heart part, I'm afraid I don't have the necessary specialty to help them. But on the law part, that's what we do, helping them resolve their dispute by putting a team together, helping understanding the underlying issues, and put them into context and help them in resolving them one way or another.
So, Alfred and Azan, you are both in litigation, and your practice area is actually quite similar. You both work in private client and divorce, matrimonial cases. Can you tell us a little bit about what are your respective roles in terms of a litigation, and give us a little bit of an introductions on the type of cases that you've worked on together?
Maybe I'll start first.
Yeah, please.
Because most of the time, we, as solicitor, will be doing the first client intake, we call it. For having the first appointment with the client, understanding their issues, trying to identify those issues and advising them on the roadmap, strategizing and helping them to resolve it by communicating with the other side and engage experts like Azan. There are cases or occasions that we do need the expertise. The reason is that a lot of time we don't go to court, especially on substantial argument, which involves a lot of case analysis. And we work with barristers like Azan as a team. They will be helping us strategizing the case and understanding the roadmap with them, their input, And we will be doing our job as managing the whole project, including communicating with the other side, helping the logistics, and talking to the client and help them putting things into perspective. I don't know whether you would agree with me.
No, I absolutely agree with your analogy of it. Well, I mean, it's a straightforward thing to say we are a team. I like to think of it sometimes like if a client had an illness and they go to the hospital, they wouldn't expect to be treated by one person. They might start out by going to speak to a GP. They might then go to a specialist. They might need surgery, and then they might require a surgeon. But just because you have a surgeon doesn't mean you've dropped your GP, doesn't mean you've dropped your specialist team. In my experience, particularly working with Alfred, Alfred is like the head of that team, looking at managing the whole of the litigation, managing really the client's problems, which might not just be one clean problem. And from time to time, you might need an expert or a specialist or a surgeon to come in to work on one particular aspect or to help shape a strategy which understands how bad things might get or the surgery you might need down the road.
And I must add that putting a team together is not just about identifying someone to work with. It's more than just that. Sometimes it's about having the chemistry. And in this respect, choosing the right barrister that goes with the client actually is something altogether as a team, as we said it. Because just because we have brilliant ideas doesn't mean that our client is receptive to it. Different people have different character and different people born with different people. And this is the reason why private clients is very different in terms of a practice area. There's no one style fit all approach.
Quite so.
Okay, I understand. So I like the analogy that you to try to explain the role of a solicitor as a GP and a barrister as a specialist. So perhaps we can try to put this into context. Now, let's try to use maybe financial disputes in terms of in a divorce proceedings, because I'm sure you both have quite a lot of experience working in this area. Can you try to let us know, let's say, what is the court process in terms of resolving financial disputes in divorce cases? And at which stage do you guys come into play, or what are your respective duties in this court process itself?
Again, I will start first because after the first client intake, we identify the issue. A lot of time it involves financial dispute, or we call it ancillary relief claim. And the first step would be the Form E, that is the financial statement. Financial statement, as we always describe, is a 20 pages form detailing the parties' income, expenditures, assets, and liabilities. A lot of people thought that it's the form. You just fill it in with figures, with hard fact. But actually, there are a lot of skills required in terms of filling that in particular, Part 5. This is what we call it pleadings. This is different from the civil claim when we have statement of claim. We have Form E in our ancillary relief claim, then that is the pleadings. And it is under oath. It is most important to plead in the right information. And that is the reason why we should engage barristers since the completion of the Form E, because what is required to put into the Form E become important. That would be evaluated, and that would be assisting the counsel in making argument in future, be it at some FDR, financial dispute resolution hearing, or mediation, or even trial. Trial is most important because parties will be cross-examined. Whatever they say in the Form E will be cross-examined. This is the reason why engaging barrister to look into it so that he will understand or identify all the necessary elements that should be pleaded in the Form E. That is how we work together as a team.
Yeah, I'm so glad you bring up the example of the Form E, which is generally speaking where a financial claim starts. I would add to that the solicitor, before the barrister even comes in, is already doing work on the financial claim even before the Form E, in drafting the petition, deciding whether or not to ask for financial relief, in writing letters before the issue of the petition and afterwards. But when we get to the Form E, and I think this is really something that sets you apart, Alfred, from most of your colleagues, most of them will let the client just fill it in with whatever they feel like filling it in. And they won't really edit it. They won't think about the strategy. They won't think about what is going to happen at the end of the case. How will this fit into the end game? And doing that, you need to think, what is our strategy? What kind of claim are you going to make, or what claims are going to be made against you? Because if you don't fill that in properly, you're quite right. You'll be cross-examined on it, or you might end up limiting your claim and end up having to drop something of value.
And also very important is to set the narrative right. This is what we emphasize on the very beginning. When we are taking the client in, understanding the story that she's telling us. And then we will be understanding what would be the claim, what would be the defense. I don't think that a lot of people approach it as such, but it is very important to me to identify the strength and weaknesses in each party's case, because at the end, we see the end game and how we're going to put it consistently throughout the whole case in order to achieve our end game. And that's what we call strategy. Mm-hmm. This is important to identify since day one. Otherwise, there will be inconsistencies in the course of a case that can run for 2 years, maybe 3. A client may not be able to understand why it is important to keep it consistent. Because at the end of the day, if it's fact, it happened, it shouldn't change. Mm. And identifying the material facts is very important to me.
I agree. I think, and I like the fact that you two pointed out how important it is to involve the barrister during the Form E stage, or at least like doing, because Form E is so-called a standard stage that you will always go through in and through relief proceedings, and this is actually a very milestone document which sets out basically the basis of your claim in terms of the finances in a divorce setting. And it is very important that when we start with the stage and we get the barrister involved, because we need to be on the same page in terms of the claim and the strategy going forward. But in terms of family proceedings in general, we know that aside from the milestone documents or the milestone the stages that we have to go through, there are also a number of situations which can be unexpected. So perhaps we might need to file a maintenance application before the Form E, or there can be a Section 17 application in terms of dissipation of assets, or an injunction when spouses have at the start of proceedings dissipated assets, and we need to quickly deal with that situation. So in terms of those situations, I understand that we will also a lot of times need a barrister's involvement. So perhaps can Azan tell us a little bit about perhaps your experience with this kind of situations and your roles and
In litigation, there are so many different permutations. Every case is different. Every client is different. Mm-hmm. And having experience of those different situations, and not just that, experience of the different judges, the different opponents, knowing how things might turn out is so valuable, particularly early on in a case when you're doing all the preparation. Bringing on a barrister, particularly an experienced barrister, is an opportunity to get that experience, which you might not have. An experienced solicitor will have a lot of experience, but that doesn't mean they would have seen everything. But the other valuable thing that you add is barristers really specialize in courtroom advocacy. And that's really two things, the legal advocacy, and the second thing is the witness handling, cross-examination, knowing how you're going to test evidence. Not only what evidence you're looking for, but also what the strengths and the weaknesses might be. And that's where you might bring in a barrister to get that additional experience and expertise. And in the long run, it can be, frankly, a little bit cheaper sometimes.
I want to add that at the end of the day, we have our clients to handle. At the same time, we do not have the privilege, like Azan, to go into court in and out.
Yes.
Literally. I always say that going to court is like going to an examination room. A lot of time, you will be facing a lot of critical questions from the judge on the law point of view or on the evidence point of view. Before every hearing, before every application, you are expected, Azan, to know your case inside out, know your law inside out, to assist the court into making the right order or directions. And this is something that I'm afraid I do not have the privilege of going into the court in and out, no matter how many cases we are doing at the moment. And that's the reason why we work together so well. We know each other's role, and we basically work as a team, that in the sense that you do your job, I do mine. You will never be you can expect what we can deliver, and vice versa.
The respect for each other's strengths.
Yeah.
Yes, I agree. And I think barristers are particularly, valuable when, there is an urgent application, where maybe we don't have all the evidence before the court, but client need the relief urgently. And this is some situation where, you really need someone who is specialized in courtroom advocacy, who knows, the different styles of different judges and the case laws inside out to persuade the judge to grant you the relief. And this is something that is, I would say, the a specialty of a barrister, and why they are so valuable to a case.
I would add to that we have the privilege, which Alfred's already alluded to, of having the time to just spend all of our time reading law, reading cases, doing research, writing books. And in practice, when you're doing practical things, when you're handling cases, you have a different kind of expertise. But sometimes judges in these kinds of applications you're talking about, they expect you to know fully all of the case law in an area, which is the job of the barrister.
And in that respect, I think one of the major difference in terms of our role as barrister and solicitor is that we do become very close with our client in the course of handling a case. And a lot of time we do side with our client in trying, absolutely. We side with our client in fighting for the best interest without having the perspective of a barrister or even the judge who is looking from above, seeing everything all together and trying to achieve justice by being fair. When we are very close to the client, it's very difficult for us being fair, to be honest, no matter how much we want to be. And this is the reason why working with barrister help us with getting another perspective to make our case stronger. In the sense that we look at our weaknesses. Sometimes we are blind by our own weaknesses.
And barristers are not afraid to deliver the bad news.
No, because it's your job to be critical.
Yeah.
I think it's particularly important in the private client practice area because, as Alfred said, we work so closely with the client, and we talk to them every day. We take instructions from them, and a lot of times we manage their emotions and everything. So it will be very helpful for a barrister to come in and, deliver like another perspective, and in terms of client management as well, to give them, let's say, what is the best scenario out of this and what is the worst scenario, so that we can, how should I put it? Like put the overall perspective before the client and let them know, what they can actually expect from a case. So, now, can we have some examples from you two, as in like what are the special cases that you have worked on before, or what are the more memorable cases that you've worked on before in terms of divorce or financial disputes?
I think we've been working together for
so many cases together,
so many years. One of the most interesting cases that we worked on was a same-sex couple. Unfortunately, one of the couple had died. They'd been married, and afterwards there are a lot of issues to do with the estate of the deceased, which we were working on together, and the complications there. But one of the most interesting things that happened in that case, I don't know if you remember, Alfred, was the question of the the other side were engaged in a campaign of harassment against the client. And the issue that came up for us was, well, how can we get an injunction to stop this harassment? The harassment included writing letters to the employer of the partner who'd survived. And we had a very interesting discussion in the High Court about the jurisdiction of the court under the Domestic Violence Ordinance, which we were quite successful in making that argument. And the judge indicated to the other side that they should concede and give us the undertakings that we sought.
Actually, that hearing, I learned a lot because in the past when we were dealing with a lot of civil cases, you issue a summons, you make an application, you have the affidavit in support, and you're trying to get the relief sought in the summons or in the draft order that we present. Of course, the court is within the jurisdiction to grant the order, but it may not be the only way that issues can be resolved. We're dealing with a situation like harassment. Okay, let's say that we get the court order or the injunction to prevent from the other side breaching or continue harassing our client. Then what? What if he breaches it? What would be the relief that we can seek against the other side? And how effective it is? Sometimes it is not just about the court order, but also getting an occasion for all the parties to be together in front of a judge and try to resolve it outside the court. This is actually a lot of time we are doing outside the family court, and that's why there are so many consultation rooms. It's very effective when people can get together and try to find a solution to it instead of forcing the court to give an order that we are asking for. And this is the reason why the court always encourage alternative dispute resolution, be it as mediation, private FDR, or any other way to resolve it, which is to facilitate communication, seek guidance on how to resolve a dispute, a lot of time in a creative way. And this is also the reason why we like working with you so much, because we are very creative, especially when the two of us speak together.
I will take that as a compliment.
Of course.
Well, I remember in that particular case, and we could talk about some other cases, but in that particular case, we showed the other side, who of course were grieving the loss of their relative, we showed them a bit of compassion and humanity outside of court. And very quickly, I think that same day or later that day, the probate matter was resolved without further argument and fight. So you're quite right. With those opportunities to speak with people in a calm way, you as an outsider, not as the client, but as a professional, to speak in a professional and a humane way, you can resolve the real problem.
And that actually reminds me of something that I was told by another petitioner. He or she sees a trend that a lot of people do get self-represented in court, in legal proceedings. And actually, we are now working on a few cases that the other side are all self-represented. While, of course, everyone can have access to justice, nobody is compelled to hire a lawyer. A lot of time, people do not hire a lawyer because they cannot afford it, or they cannot find the right lawyer. But then, at the same time, they are deprived of this opportunity to have professional help. In the complex legal proceedings, there are not just one way to resolve a dispute, and sometimes the professional assistant would help them to get into perspective, understanding the consequences in a clearer and sustained manner, and help to resolve the dispute. The sooner the better. If only some of the litigant in person will hear this podcast and start hiring a lawyer, not necessarily us, but then there would be a lot of time and money saved if they get right assistance since the beginning. A better outcome, yes, absolutely.
Well, I've had the recent experience of someone who couldn't afford to hire lawyers to work on the case full time. But nonetheless, that person is, let's say, sufficiently articulate. They can speak to their own case. But they would still come to us for advice or have us review the documents, the submissions to the court separately from that. And I think at least even that is better. Having at least some advice holding yourself forward rather than being truly out at sea on your own. Because some cases I've seen people spend years without any result, and time, money has all gone to waste, and their relationships have only deteriorated.
And the whole thing is exacerbated when the legal process in Hong Kong is so complicated and so long that if you do not have a lawyer, you do not get it resolved at the very beginning, you end up spending more time and cost on it, and especially at the time when there's an economic recession. The longer you wait, the longer that the money will get dwindled away, eroded by basically recession. So this is more of a reason for parties who engage, who get into dispute, to get it resolved with the professional help as soon as possible.
There's another case that we worked on recently, which was a pre-nuptial case. There was a pre-nuptial agreement. And I look at the case, and it's a very typical thing. The husband comes from France, where having a prenuptial agreement is actually normal. I think most married couples do get a prenuptial agreement. But the problem was, although he was living in Hong Kong, he had not received advice from Hong Kong lawyers about the terms of the prenuptial agreement. In the end, we took him to court. I think we were quite successful. But when I look at that case, I think how many people are like this, where they're not going to the specialists to get advice before there is a problem, and in the end, it can cause a real long-term problem and be very costly.
So, Azan, you've talked about this case involving a prenuptial agreement, and I think it is more and more common that people nowadays enter into prenuptial agreements before they're married, or even postnuptial agreements to cater for the situation, when there's unfortunately a divorce. Can you tell us a little bit more about, the laws on prenuptial agreement in Hong Kong, and why is it necessary to have an expert to look into this matter before it is signed?
Well, I would say, first of all, that it is sensible for everyone to get a prenup. Of course, it matters what the prenup says, but it's not just for people who want, if you like, a one-sided prenup. Everyone should get a prenup because you don't want to be in the situation where, when the relationship is broken down, just at that minute is also the minute you need to be able to communicate. A prenup is basically an opportunity, when cool heads are prevailing, to write down what you would want to happen in the event of the dissolution of a marriage. And whether that's 50-50 or some other arrangement, a prenup is better than nothing. Now, that said, it's important to remember, whether a Hong Kong prenup or a foreign prenup, a prenup is not going to bind the court. It is not a contract like a commercial contract. It instead is something that the court may take into account. And the court is more likely to take a prenup into, or for that matter, a postnup into account, depending on the terms. One of the most important things is that the way in which the agreement was reached was fair. Both sides understood what they were signing. Both sides ideally had the chance to seek legal advice. They don't necessarily need to have taken legal advice, but they do need the real opportunity. They should be having their faculties at the time when they sign the prenup. There shouldn't be any duress or coercion to make them sign the prenup. But beyond the formal requirements of the prenup, then there's the substantive version. So the court, if it's a formally valid prenup, may take it into account, but it's more likely to give it full weight if you can say that there's fairness in the outcome.
A lot of time, people come to me and say, I have popped this question up of prenup, but it was right out rejected by the other side, saying that, it's not lucky to talk about divorce before even marriage. Unromantic. I'm not after your money, or something like that. I think it's all because of a prejudice about prenup. Prenup is actually not about divorce. It's about managing the finances in the course of the marriage and the expectation among the parties. This is actually very important. We are talking about two people spending the rest of their life together. It's not just happily ever after. There are a lot of aspects to consider. Children, of course, a lot of people plan about this. But then finances is also very important. It's very simple. For example, are you guys expected to have children? After you have children, is one of you wanting to stay home and mind children full-time, knowing that nowadays minding children is a full-time job? And at the same time, when one party is not working, half of the income, or even more maybe, would be deprived from the family. And Hong Kong is a very expensive place to live. Mm-hmm. What is expected from each other in terms of their role in the family? This is all part of the family planning. And afterwards, once there is a very good understanding, we also have to cater for changes. Prenup is not about, just an agreement set in stone and no changes in the future. Of course, this is an agreement made at the beginning of a relationship. After the relationship proceeds, things change, people change. But there are some fundamentals that should not have changed, or even if it's changed, it should be agreed among the two parties in a marriage. That's what we call understanding, and that's part of the love and respect and commitment. This is how people manage their relationship or in the course of a long process. And prenup, therefore, should not be shunned against. I mean, this is prenup talking about people, how they're managing their finances and managing their expectation to each other.
Yeah, if I were allowed to give one message to clients, I would say having a prenup is a loving thing to do for your spouse. Actually, it is a loving thing to do. Now, of course, you can do it in an unloving way. Of course, you can do anything in an unloving way. But it fundamentally, what you are doing is you're being responsible. You're having that discussion about your financial life rather than pretending that life doesn't have hard choices. Life doesn't have difficult moments. This is part of real life. And if you really respect your partner, then you should be able to have those conversations. And if it is difficult to have those conversations, well, that may be the time to involve a third party, because in the long run, you may save yourself and them a lot of grief.
I cannot agree more.
Yeah. I sometimes like to compare a prenuptial agreement to a will, as in people think it is a bad luck to do a prenup, and they kind of avoid it. Generally, the stereotype of around wills are less these days, but with prenups, it's still pretty much existent. And but the thing is, it actually caters for the situation where something bad happens. And I agree with Azan. It's actually it can be an act of love, and it's you offering your partner the discussion and the opportunity of coming into an agreement to cater for some unlucky situations in the future.
Or we call it protection.
Yeah. And also with a prenup, you can be very flexible and creative in terms of the terms, as long as they are fair. And this might not be the opportunity that you might be offered by the court if there is no prenup, and then you will have to go through a divorce in a very contentious way.
Of course. At the same time, we're saying that we are very creative. In terms of prenup, I don't know how creative we want it to be, because we all know very well how the court will assess the situation, and therefore, in terms of prenup,
we know.
We know.
Yeah, and I actually fear that even most solicitors handling family cases are not actually specialists, and they may not know the reality, because I have seen now too many prenuptial agreements where apparently some Hong Kong solicitors looked at it and the quality of advice given was really, really not from someone who knew the area. And that is something hopefully will change in the future.
Yeah, and I think that's why we need specialists to prepare these kind of documents, as in you will need to know the extent of creativity you can incorporate in the terms, and whether or not they will be and how the court will actually look at those terms, and what you can expect.
In fact, I would add one other really important thing. People's financial lives are not siloed.
Yeah.
Where no man is an island, especially not in Hong Kong. And very often people they have financial links with friends, with family, and they may be holding things on trust for people, or they may be holding things in tandem with other people. And if you don't have a clear disclosure to your partner at the beginning of the marriage, if you're not open about those things and it's not recorded, you might not only be causing a problem for yourself, you might be causing a problem for your whole family or all of your friends. Leave aside the expense of having disputes about these things. Now, as I said before, a prenup might not remove the possibility of a dispute, but it can significantly reduce the cost and scope of such a dispute.
So we've talked about divorce cases that you've worked with, and you've also mentioned that there is this case concerning inheritance provision for a same-sex couple from an estate. So can you tell us a little bit about this area of work that you do and any particular cases other than that you've mentioned, and give us some stories?
Well, I'll do my best. There are, in a way, as you were saying before, wills and prenuptial agreements, there's some kind of comparison there. I would say that people's antipathy towards prenuptial agreements is partly driven by their ignorance about what the law says happens in divorce. But likewise, people's failure to write wills is partly driven by their failure to understand what happens when you die to your estate. They may not fully understand, two things. What happens when you don't have a will? There's something called intestacy, where there are certain rules drafted by the government that provide that portions of your estate may go to certain relatives or your spouse. But those rules are not necessarily what people think they are. They're slightly more complicated than your spouse gets everything or your parents get everything. It's a little bit more complicated than that. But even whether you have a will or you don't have a will, there is another kind of provision called an inheritance provision. And there's a separate ordinance dealing with that, which provides for discretion with the court, specifically the family court, to give maintenance and other orders for the benefit of your family members if you die, including family members that you fail and including non-family members that you fail to provide for in your will. So in the context of same-sex couples, if the couple is married abroad, at least for the moment, following a case called Ung and the Secretary for Justice, and now Lee and the Secretary for Justice, it has been decided already by the High Court that a same-sex married couple will be treated the same as an opposite-sex married couple. But even if the couple is not married, they may still fall under what I think is sometimes called the mistress exception. There is a provision in the inheritance ordinance that allows for a court to give maintenance and other financial orders for people that you have maintained during your life and that were being maintained at the time you deceased. So, for example, if there's a couple, whether they're same-sex or opposite-sex, it doesn't really matter, who were living as though they were a married couple, and one of them is dependent on the other, and the person who's providing financially for the dependent then dies, then the dependent person can apply to the court for what we call financial provision.
I think thanks to Azan, same-sex couple can now claim the same right as some heterosexual couple. But actually this emphasizes the importance of couples getting married. Just for example, the example that you mentioned, people who live as husband and wife or husband and husband or wife and wife without getting married. Our Hong Kong law is actually very simple. You either got married or you're not. And if you have gotten married, the court can look into it as in a divorced couple in the context of what we call 481 inheritance provision claims. That would be a divorce standard. And we're talking about the difference between need case and a sharing case. A simple dependent, based on other provision in the section, will only have a need case. Basically, that is the need of that person, the reliance financially on the deceased, and what should be awarded to provide such need. That is the Hong Kong law position. But if the couples are married, they will be looking at contribution towards the accumulation of wealth. And if it's beyond the need of a party, applying the DDLKW principle, there will be a sharing case. At least it will be compared against. We're talking about very different amount, especially when we're talking about a substantial accumulation of wealth. And that is something that not a lot of practitioners are aware of. Unfortunately, when they're drafting a will, they didn't take proper instructions and then put in the right provision to avoid such a claim. A lot of time it's about understanding how the survivor understand the wishes of the deceased or the testator and why they have such a decision. Think about it. You marry someone and then that person passed away and then you get disinherited without any reason. Why? Perhaps you know, perhaps you don't know, but that becomes litigation. That is the main reason for litigation. And to put it in a more complicated context, when we're talking about multi-jurisdictional wills, multi-jurisdictional estate dispute, what you envisage may be very different from what it actually happens. We're currently handling one case that the son of an ultra-high net worth deceased is disinherited, and he made a claim against the estate. Even though he's not a financial dependent during the deceased's lifetime. Why he has a claim? Because he claimed it in Australia. Australia has a completely different yardstick in terms of assessing such a claim. And it's more likely than not that such a claim would be successful. Compared with Hong Kong, he would probably have no luck in Hong Kong. But only because he passed away in Australia, he has the claim in that state, and it's very likely that he would get something. And not to mention that he's not the only son who gets disinherited. And the message that I want to bring out is that, especially when there is an international context, we really need to take a good estate planner to advise you properly on how to avoid this kind of claim.
Yeah. So, thank you. And you both brought up the topic of same-sex couples and provisions for them from the estate in the event that one of them dies. So I understand that, Azan, you have had quite a lot of experience in terms of public law and fighting for not only the LGBTQ community but also people who are underprivileged. So can you tell us a little bit about the public law work that you do and what usually is your your battlefield or your area of interest? Yes.
Well, I have been doing public law from the beginning of my practice, and I do remember going to law school and thinking to myself, I'm going to do trusts, and I'm going to do property, and I'm going to do company work, and then as soon as I got into practice, it's not that I didn't do any of that work. It's just I was just so much more attracted to real people, real problems.
I always thought that you are a human rights warrior.
No. I started out being all about very hard law. But, I mean, that's basically what you were saying earlier, Alfred. I was just much more attracted. I just couldn't say no to people. And I was really motivated to do work where I felt real people were going to be really affected. It's just much easier to do that for me. And the kind of public law work I've been doing, you can say that public law is, people have the wrong idea about public law. What public law is about getting authorities to comply with the law. That's what it's about at the end of the day. People think, oh, you're challenging this, No, what you're really doing is you're going to court and you're saying, court, give guidance to the government about what the law is. Now, there are different reasonable, sometimes unreasonable views about what the law is. but we're not. You're going for the public purpose of assisting the government or a public body to understand what the law is, what it requires of them. Now, I have been drawing these two threads together. I've always had an interest in complex law, i.e. overlapping different areas. You call me creative is only because I see law as a giant web, and I consider it my obligation to figure out how all the threads overlap, how things are connected. And so I got into public law, and the kind of public law I do has generally speaking been about individual basic rights and how, well, frankly, our constitutional rights, they came into place in 1991 and then 1997. But most of our laws are written before 1991, and they haven't got up to speed. They're not updated yet, and so I'm never worried that there won't be enough work for me to do, because there's a lot of ways in which the law needs to catch up with the higher law, which is the basic law.
Thank you. So, aside from your involvement in public law and in the courtroom, I understand that you also have a lot of public initiatives outside of the courtroom. So, is there any pro bono work or community campaigns or services that you do?
I'm in a way very happy to talk about some of these things. I do think that lawyers are in a privileged position. And our privilege is our expertise in the law and our understanding of how government, policy, and the law is supposed to work. And that's a real opportunity for us to contribute to the public good. And, I wouldn't diminish in any way the work done by Alfred pushing for improvement in other areas. Now, what I do is I spend a lot of my time advocating children's rights. I'm the chairman of the Hong Kong Committee on Children's Rights, which is a non-partisan group filled with experts in different areas of child development, child protection, children's rights, and child law. And our role is really to coordinate between the non-government community and the government itself to improve public policy related to children, the care of children, the education of children, child protection. Aside from that, I do some other things. I don't want to make myself different than what I am. I try to do things that I find fun and interesting. For example, the last couple of years, which I really encourage anyone to get involved with, I have been working on an initiative to recognize the contribution of the South Asian community to Hong Kong. In particular, people may not know this, but many of the troops, I think if not most of the troops that defended Hong Kong against the Japanese during the Second World War were Indians. Many of them were punished cruelly by the Japanese during the invasion. Many of them died defending Hong Kong. There is actually a couple of memorials to these soldiers. One of them is in Happy Valley, and a few years ago I went to visit it on Remembrance Day, and I noticed that there was nobody else there. And I also noticed that the jungle had taken over this site. And what I wanted to do, and I very quickly found there were so many people who wanted to help because they didn't know about it. And we cleaned up that graveyard and the memorial, and ever since then we've been having these annual remembrance days where we go along to commemorate the contribution of these soldiers. So sometimes I do stuff like that, but I'm not going to say. I mean, it's been fun. Like it's more fun than you would think cleaning up a graveyard.
At the end of the day, I think we all do things that we believe in. Be it as the law, be it as the charitable cause, or other things in life that we believe in that adhere to our value. To you, there are a lot of things, for example, children's rights. These are what we talk about, vulnerable groups that requires our help, especially when we have been privileged to have the legal training, to have the experience. This is a little things that we can reward back to the society. Who else would be in a position to do what we can do in terms of protecting children's rights, minority rights, be it as South Asian or LGBT or any other vulnerable groups. These are the people that need our help.
Well, I'll give you an example. I have been volunteering at Mother's Choice since I was like 8 or 9, paint things, go along to gala dinner, all these little things. It's only when I became a lawyer and I started to volunteer with my twin brother, who's also a barrister, we said, you do need any legal support. And we discovered that there were so many cases of institutionalized and abandoned children. They really needed lawyers. And unfortunately, there are no lawyers specializing in this area. And now in practice, Siobhan and I, my brother that is, we specialize in child protection law and adoption law. There really are very few other people who do this area law because there is no money. But on the other hand, 2 things. One, there is nothing more exhilarating than feeling like you have changed the course of a child's life. And the other thing is, like I said before, we are privileged to be lawyers. We are in a position to do something. If no one else will do it, then it must be our obligation to do it.
And we believe the children are our future.
Yeah.
Yes,
I agree.
And I think that is actually the reason why we go into private client practice in the first place, because we want to help people and we want to use our professional knowledge to help people, and it's different from commercial litigation or corporate work. Which not to say that these works are not worth doing, but that with private client work, there's always a human side of things and
immediate gratification of helping a person you meet.
It's very different. The dynamics are different. The psychology is different. And this is the reason why there's specialists, private client lawyers, and we don't try to compete with the commercial litigator.
To all of my corporate clients, of course I enjoy helping you too.
The level of connection that you have with the private client is always very different compared to...
Well, I find that my corporate and commercial clients, many of them, they also want to be involved in helping real people, particularly children, minorities, and vulnerable groups. Everybody across the board wants to do what they can.
Yeah, so I think with that note, thank you very much for coming to this podcast today, and I enjoy a lot speaking with you too. And with this note, this is the end of this podcast, and I hope you enjoyed it as well. Thank you.
Thank you.
Tune in and listen to more episodes of the Hip Talks podcast by checking the Insights section at www.hugolandip.com and the dedicated channels on Apple Podcasts, Spotify, Google Podcast, and Stitcher. They are also available on Hugo and Ip's YouTube channel. You can send comments and feedback to the email address hello@hugolandip.com. Please share the Hip Talks with friends, family, and business associates. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.